Imagine waking up one day to find your name missing from the voter list. No vote, no ration card, no caste certificate because the government process quietly decided your citizenship was doubtful. If your name is struck off the voter list, are you still an Indian citizen? Well, the Supreme Court has now said this. In some form, at least 4 separate times in the last year, most recently on the 18th of July, and each time the message has gotten sharper. The Election Commission can clean up the voter list. It cannot decide who belongs to this country. That's exactly what the Supreme Court reiterated on the 18th of July this year in a case out of West Bengal. Hello and welcome. You're watching NewsX Deepdive. I'm Vineet Malhotra, and tonight we break down exactly what the court ruled, what SIR does and does not test for, why neither your Aadhaar card nor, for most Indians, your passport settles the question, and what actually does and what happens next to the lakhs of people caught in this limbo. To understand this ruling, you need to understand SIR, the Special Intensive Revision of Electoral Rolls. SIR is basically a deep cleanup of India's voter list. Election officials go door to door, checking whether every name on the roll actually belongs to an eligible living resident Indian citizen. It started with Bihar, then expanded including West Bengal ahead of state elections. The state goal: remove duplicate entries, dead voters, people who have shifted, and controversially, people whose citizenship itself is in question. The last category is where the trouble begins, because the moment doubtful citizenship becomes a reason to delete someone from the rolls, a much bigger constitutional question opens up. Does the Election Commission, a body built to run elections, have the authority to decide who is and who is not an Indian citizen? On 18 July, a bench led by Chief Justice of India, Suryakant, along with Justices Joy Malia Bagchi and V. Mohana, was hearing a petition from Prasenjit Bose, who heads the SIR committee of the West Bengal Congress. His complaint: people whose names were deleted or still pending appeal were being denied welfare benefits like ration cards and Annapurna Yojana simply because of their SIR status. The bench used the moment to hammer home a principle it had already laid out earlier in its Bihar SIR judgment. The Election Commission is not a constitutional authority when it comes to Article 9, 10, 11 and 12 of the Constitution, the very articles that govern how Indian citizenship is gained, lost or continued. Justice Bagchi put it plainly: the EC, and I quote, can decide not to include someone on the electoral roll, but that decision does not result in loss of status or citizenship per se. In other words, deletion from a voter list is an electoral decision. It is not a legal determination of nationality. Those are handled by two completely different pieces of law: the Representation of the People Act for elections and the Citizenship Act 1955 for citizenship itself. So if the EC can't decide citizenship, who can? Well, the court's answer: the Union government, specifically the competent authority designated under the Citizenship Act. This isn't a new idea. It traces back to an earlier, more detailed Supreme Court judgment on the Bihar SIR exercise, where the court laid out a clear chain of responsibility. Here's how it's supposed to work. Section 16 of the Representation of the People Act disqualifies non-citizens from being on the electoral roll. So the EC does have a job to do here. It has to satisfy itself that people on the list meet that basic threshold. If it finds a case where citizenship looks doubtful, it can exclude that name. But that's where its authority ends. From there, the EC has what the court called a corresponding duty. It must forward that person's case to the Union Home Ministry within a set window for actual adjudication under the Citizenship Act. The affected people have to be given notice and a hearing, and if the government ultimately decides the person is a citizen, their name goes back on the rolls. So picture it as a relay race. The Election Commission runs the first leg, checking the voter list. The moment citizenship itself is in question, it hands the baton to the Home Ministry, which runs the second leg under a completely different law. The problem the court is now grappling with in this most recent West Bengal case is that this handoff isn't happening cleanly. People are stuck in the gap between legs of the race. This is where the ruling stops being abstract constitutional law and starts affecting real lives. The petition that brought this to the court's attention flagged something serious. Over 34 lakh appeals against SIR deletions are still pending. And in that pending period, while someone's case is literally unresolved, reports suggest they are being denied basic welfare. PDS food rations, the Annapurna Yojana for elderly citizens, case certificates needed for reservations and scholarships. Think about what that means practically. A person has not been declared a non-citizen by any competent authority. Their case has not even been decided, but functionally they are already being treated like one cut off from the safety net that citizenship is supposed to guarantee. This is exactly the harm the court was trying to head off when it said deletion from the roll does not equal loss of citizenship. The legal status is unchanged, but without enforcement of the principle on the ground, at ration shops, at panchayat offices, the distinction becomes meaningless for the person actually affected. That's why the court issued notices to both the Election Commission and the West Bengal government on this specific petition. It's now asking them to explain how this appellate and referral process is actually functioning or failing to function in practice. This is not just a West Bengal story. SIR style revisions are rolling out more broadly. Bihar was first, Delhi's final rolls were reportedly due later this year, and other states are watching closely. Every time this exercise touches a name with doubtful citizenship, attached the same fault line reappears. An electoral body making a preliminary call and a citizenship authority meant to make the final one. The Supreme Court's insistence on keeping these separate isn't just legal formalism, it's a safeguard against a scenario where an administrative voter roll exercise quietly becomes a backdoor citizenship test applied without the due process the Citizenship Act actually requires. At the same time, the court isn't saying the EC has no role at all. It upheld the SIR process itself and confirmed the EC can and should flag doubtful cases. It just can't be the final word. That balance, real scrutiny of the rolls, paired with proper legal process before anyone loses access to citizenship-linked rights, is the tightrope the court is trying to walk. So where does this leave things? The principle is not about as clear as the court makes it out. Being struck off a voter list is not the same as being struck off as a citizen. The Election Commission checks the rolls. The Union government, through the Home Ministry, decides citizenship with notice, a hearing and a real process. What's still unresolved is the machinery underneath that principle, whether referrals are actually happening within the required time frame, whether people get their hearings, and whether welfare benefits are being wrongly withheld in the meantime. That's exactly what the court is now demanding answers on from the EC and the West Bengal government. Dr. G.V. Rao, Senior Advocate of the Supreme Court, is with us on the program. Dr. Rao, appreciate you being here with us. Well, this is a two-edged sword, isn't it? If you are not considered a citizen and you can't vote, right, and you can't even equate yourself with what the citizen with the SIR approval is getting. The benefits are withdrawn. You looked at with a certain sense of suspicion. Did the courts and the Election Commission actually think this through before they started out?
Well, see, one of the important aspects of being a citizen is to have the right to vote. Now, when anyone is a citizen of India, let us say, all of what the Constitution and the legal system provides, the person has rights, which includes fundamental rights, etc. And right to exercise franchise is also a vote for a citizen of the country. Now, given the fact that we've had migration, illegal immigrants, etc., from neighboring countries, etc., and which has been a serious issue, especially border states, the question whether some person is a citizen or not is a very important one, because that is what determines in the democratic process who is going to be in the government. Now, the first step in dealing with democracy and dealing with who is a citizen or not and whether he can exercise his franchise or not is to determine whether he falls in the various requirements and the categories of being a citizen in order to be able to vote. That's why the courts, what they have said is, all right, you are denying him a vote because of serious suspicious circumstances, which you are doing when you are giving him a right to vote, and they look at every aspect to determine broadly whether the person is a citizen and therefore has a right to vote. Now, where there are doubtful cases under the Citizenship Act, the central government is the authority which determines whether you are a citizen or you have given up your citizenship or whether you are not a citizen at all. So therefore, this dichotomy that somebody who is denied a right to vote, for instance, whether he is a citizen or not is a matter for the central government to decide by their designating authority. Merely because somebody's right to vote has been kept in abeyance on account of several circumstances, on an inability to provide sufficient documentation, on account from shifting from one part of the country to another part of the country, so on and so forth. If that is the case, the court has held that merely because your name doesn't figure in the thing. Now, your second question, that based upon that, since your name is not on the voters list, a person is being denied various welfare provisions or welfare schemes, etc. Now that is again a very difficult scenario for, let's say, those who are implementing those provisions of welfare schemes, because how does that person show that he continues to be a citizen? Let us say he doesn't have an Aadhaar card, he doesn't have a passport, he doesn't have a residence or a ration card, any of the following things, because the scope is very narrow. I think some people are being alarmed for no reason. Because if the category of persons who do not have any of the following things, which is a birth certificate, Aadhaar card, ration card, any of these I would say is a very small, minuscule number who are who can easily be determined whether they are citizens or not. If they have none of them, obviously they have to show how and where they have lived, and because you see, citizenship is various of that. Citizenship by birth, citizenship by naturalization, citizenship by descent, that your parents were citizens of the country. So there are various processes by which you determine. And if a person doesn't have anything to show that he belongs in this country, then that category is definitely perhaps which is a illegal citizen, illegal entrant, and a person who's a non-citizen. Therefore, the question whether they should extend welfare schemes to that particular narrow, very small, minuscule number who has no evidence to show, how he is in the country. Well, it is for those people to determine, and I'm sure it is not with a view to creating any kind of unfairness or injustice towards any of those people who are residing in India, even if they don't have sufficient documentation.
All right.
That is not.
Fair enough, sir. We've run out of time, but I appreciate your time and your perspective on the same. We take a short break. Be right back.
देखिए, सिर्फ मेरे कहने पर टर्म इंश्योरेंस